Good day, future lawyers. Welcome back. Our video for today is about justifying and exempting circumstances under Articles 11 and 12 of the Revised Penal Code. You will also find recent bar questions and relevant jurisprudence for further reference. Now let's get started. Article 11. Justifying circumstances. The following do not incur any criminal liability. Anyone who acts in defense of his person or rights, provided that the following circumstances concur. First, unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. Third, lack of sufficient provocation on the part of the person defending himself. Anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or of his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the next preceding circumstance are present, and the further requisite, in case the provocation was given by the person attacked, that the one making defense has no part therein. Anyone who acts in defense of the person or rights of a stranger, provided that the first and second requisites mentioned in the first circumstance of this article are present, and that the person defending be not induced by revenge, resentment, or other evil motive. Any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared be greater than that done to avoid it. Third, that there be no other practical and less harmful means of preventing it. Any person who acts in the fulfillment of a duty or in the lawful exercise of a right or office, and any person who acts in obedience to an order issued by a superior for some lawful purpose. In the case of People versus Nugas, unlawful aggression is of two kinds: A. Actual or material unlawful aggression, and B. Imminent unlawful aggression. Actual or material unlawful aggression means an attack with physical force or with a weapon, or offensive act that positively determines the intent of the aggressor to cause injury. On the other hand, imminent unlawful aggression means an attack that is impending or at the point of happening. It must not consist in a mere threatening attitude, nor must it be merely imaginary, but must be offensive and positively strong, like aiming a revolver at another with the intent to shoot, or opening a knife and making a motion as if to attack. Imminent unlawful aggression must not be a mere threatening attitude of the victim, such as pressing his right hand to his hip where a revolver was holstered, accompanied by an angry countenance, or like aiming to throw a pot. People versus Nugas, November 2011. Self-defense cannot be justifiably appreciated when uncorroborated by independent and competent evidence, or when it is extremely doubtful by itself. Indeed, in invoking self-defense, the burden of evidence is shifted and the accused claiming self-defense must rely on the strength of his own evidence and not on the weakness of the prosecution. To successfully invoke self-defense, an accused must establish 1. Unlawful aggression on the part of the victim, 2. Reasonable necessity of the means employed to prevent or repel such aggression, and 3. Lack of sufficient provocation on the part of the person resorting to self-defense. Velasquez versus People, March 2017. The relatives of the accused for purposes of defense of relative under Article 11, Paragraph 2 of the Revised Penal Code are his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or of his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degree. Relative by affinity within the same degree includes the ascendant, descendant, brother or sister of the spouse of the accused. Under the Revised Penal Code, a person who defends a person who is not his relative may invoke the defense of a stranger provided that all the elements exist, to wit, a. Unlawful aggression, b. Reasonable necessity of the means employed to prevent or repel the attack, and c. The person defending be not induced by revenge, resentment, or other evil motive. The defense of property is not of such importance as the right to life, and defense of property can only be invoked as a justifying circumstance when it is coupled with an attack on the person of one entrusted with said property. Question. Standing trial for frustrated murder, Aramis pleaded self-defense. The prosecution's contention was that the plea of self-defense applied only to consummated killings. Rule with explanations on the tenability of Aramis' claim of the self-defense and on the prosecution's contention. Answer. The prosecution's contention is not tenable. Shooting the leg of the victim without killing him may be a reasonable means to prevent or repel an actual or imminent unlawful aggression. Hence, self-defense is not confined to consummated killing. In the process of proving a justifying circumstance, the accused risks admitting the imputed acts which may justify the existence of an offense were it not for the exculpating facts. Conviction follows if the evidence of the accused fails to prove the existence of justifying circumstances. The accused's admission enables the prosecution to dispense with discharging its burden of proving that the accused performed the acts which would otherwise be the basis of criminal liability. All that remains to be established is whether the accused were justified in acting as he or she did. Article 12. Circumstances which exempt from criminal liability. The following are exempt from criminal liability: an imbecile or an insane person, unless the latter has acted during a lucid interval. When the imbecile or an insane person has committed an act which the law defines as a felony, the court shall order his confinement in one of the hospitals or asylums established for persons thus afflicted, which he shall not be permitted to leave without first obtaining the permission of the same court. Number 2. A person under 9 years of age. Number 3. A person over 9 years of age and under 15, unless he has acted with discernment, in which case such minor shall be proceeded against in accordance with the provisions of Article 80 of this Code. When such minor is adjudged to be criminally irresponsible, the court, in conformity with the provisions of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with his surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in Article 80. Number 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Number 5. Any person who acts under the compulsion of an irresistible force. Number 6. Any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. 7. Any person who fails to perform an act required by law when prevented by some lawful or insuperable cause. Insanity exists when there is complete deprivation of intelligence in committing the act, that is, the accused is deprived of reason, he acts without the least discernment, because there is complete absence of the power to discern, or that there is total deprivation of freedom of the will. Mere abnormality of the mental faculties will not exclude imputability. Sharjadov of Latvia suffers from a psychotic disorder after he was almost assassinated in his previous assignment. One day, while shopping in a mall, he saw a group of shoppers whom he thought were the assassins who were out to kill him. He asked for the gun of his escort and shot 10 people and wounded 5 others before he was subdued. Volvic committed 5 frustrated murders for the unwounded victims and 5 frustrated murders for the wounded victims. His psychotic condition is not an exempting circumstance of insanity in the absence of showing that there is a complete deprivation of intelligence in accordance with the cognition test. The defense of insanity is in the nature of a confession or avoidance, because an accused invoking it admits to have committed the crime but claims that he should not be criminally liable therefor because of insanity, which is an exempting circumstance. Consequently, the accused is tried on the issue of sanity alone, and if found to be sane, a judgment of conviction is rendered without any trial on the issue of guilt. However, an accused invoking the exempting circumstance of insanity bears the burden of proving it with clear and convincing evidence, because every person is presumed sane. For the defense of insanity to prosper, it must be proven that the accused was completely deprived of intelligence, which must relate to the time immediately preceding or simultaneous to the commission of the offense with which he is charged. A man may behave in a crazy manner, but it does not necessarily and conclusively prove that he is legally so. In order to be exempt from criminal liability, the accused must be so insane as to be incapable of criminal intent. Vague references to his history of mental illness and subsequent diagnosis of schizophrenia do not satisfy the quantum of proof required to exempt accused appellant from criminal liability, especially since the defense failed to establish that the accused appellant's mental ailments, if such was the case, related to the time of the commission of the crime. In order that a person could be regarded as an imbecile within the meaning of Article 12 of the revised Penal Code so as to exempt from criminal liability, he must be deprived completely of reason or discernment or freedom of the will at the time of committing the crime. For the exempting circumstance of uncontrollable fear to be invoked successfully, the following requisites must concur. 1. Existence of an uncontrollable fear. 2. The fear must be real and imminent. And 3. The fear of an injury is greater than or at least equal to that committed. It must appear that the threat that caused the uncontrollable fear is of such gravity and imminence that the ordinary man would have succumbed to it. It should be based on real, imminent, or reasonable fear of one's life or limb. A mere threat of a future injury is not enough. It should not be speculative, fanciful, or remote. A person invoking uncontrollable fear must show, therefore, that the compulsion was such that it reduced him to a mere instrument, acting not only without will, but against his will as well. It must be of such character as to leave no opportunity to the accused for escape. The defense of Golfeo that they acted under the pressure of an irresistible force and that they merely obeyed the order of their commander is clearly untenable, not only because of the well-settled rule that obedience to an order of a superior will only justify an act which otherwise would be criminal when the order is for a lawful purpose, but also because the circumstances under which Golfeo participated in the torture and liquidation of Areza cannot in any way justify his claim that he acted under an uncontrollable fear of being punished by his superiors if he disobeyed their order. The law exempts from criminal liability any person who acts under the circumstances in which the appellant acted in this case by giving birth to a child in the thicket and later abandoning it, not because of imprudence or any other cause than that she was overcome by severe dizziness and extreme debility with no fault or intention on her part. She should not be blamed therefore, because it all happened by mere accident. From liability any person who so acts and behave under such circumstances. Taking into account the foregoing facts and considerations, and granting that the appellant was aware of her involuntary childbirth in the thicket, and that she later failed to take the child therefrom, having been so prevented by reason of causes entirely independent of her will, and it appearing that such circumstances said appellant has the fourth and seventh exempting circumstances in her favor, is hereby acquitted of the crime of which she has been accused and convicted. People versus Badian, September 1936. Thank you all for watching. Like Pinay Jurist on Facebook and follow Pinay Jurist on Twitter. And don't forget to subscribe. Thank you!